Balake. Where is Balake at?
My name's Blake.
Do you want to go to war, Balake? I'm for real. Ron.
Ron is right here. Thanks for joining me once again, everyone. Guys, this is a really interesting one today. This has to do with Scientology giving the game away inadvertently on its own website, publishing material that does seem to completely contradict the claims Scientology is currently making in court, that Scientologists who leave Scientology, depart, get expelled, are declared suppressive persons by Scientology, are still required to follow Scientology's own internal justice procedures in the form of internal arbitration when former Scientologists choose to bring a lawsuit against Scientology. As many of you know, almost every single lawsuit that gets filed, we're talking about a civil lawsuit, not a criminal case, every single lawsuit that gets filed against Scientology, Scientology trots out all of these agreements that Scientologists are forced to sign, and they go, Your Honor, these Scientologists have signed agreements to always take any complaint to an internal religious arbitration, and you must not let this case proceed in a court of law. And this is a whole charade that Scientology has created for just the simple purpose of not getting sued. And it is a charade, and Mike Rinder has given many explanations for how it is a charade, and he speaks with authority because he is one of the people who, as a very senior executive in Scientology, was responsible for creating, constructing, and implementing this very charade. Now you go, what do you mean a charade? Is an internal arbitration, or is there one or isn't it one? What do you mean a charade? In the entire history of Scientology, it had never conducted an internal arbitration until just a few years ago. And they were facing a lawsuit by former Scientologist Luis Garcia. Luis Garcia, by the way, is the president and chairman of the Aftermath Foundation. I'm the vice president of the Aftermath Foundation. Other board members are Mark Headley, Claire Headley, Mike Rinder, Christy Colburn, and Ray Jeffrey. We help people who are escaping from Scientology. But anyway, Luis Garcia was suing the church on like a financial fraud, deception issue. And they were saying this has to go to internal arbitration. And the court asked Scientology, so what is your procedure for an internal arbitration? Scientology's lawyers were caught off guard because there is no procedure. Not only had one never been conducted, because L. Ron Hubbard never created something called an internal arbitration. So not only had one never been conducted, but for that same reason, there was no policy on how to do one. There was no procedure. So Scientology said, Your Honor, I don't know why I'm always a Southern lawyer. Your Honor, the procedure for a internal Scientology arbitration is as laid out by L. Ron Hubbard in the policies concerning committees of evidence. A committee of evidence, or a ComEv, is a part of Scientology's internal justice procedures. You could loosely equate it to the Scientology equivalent of like a court martial. It is considered the most severe ethics and justice action short of actually being expelled from Scientology. The idea that a committee of evidence is the procedure for an internal arbitration is pretty crazy. But I want to show you something Scientology published on its own website that would tend to invalidate and contradict the idea that a former Scientologist could ever even be required to, or could even do, or would even be allowed to receive a committee of evidence in Scientology. And here's what I'm talking about. This is it looks like it's an archived page from Scientology's website, and it has to do with the definition of fair game. What does the term fair game refer to? Fair game is a term which is often intentionally misrepresented and used by apostate Scientologists. Apostate is someone who has left a faith or a religion. Fair game is a term which is often intentionally misinterpreted and used by apostate Scientologists and other critics to unfairly tarnish the church. The fair game policy was canceled in 1968, more than 4 decades ago, expressly because it was susceptible to misinterpretation and misuse. In fact, the policy of declaring people fair game is what was canceled, not the policy on treating people in accordance to how the fair game policy said they should be treated when they are declared enemies of Scientology. The term meant that apostate members could not seek protection, or refuge under the church's internal ethics or justice codes. It had been intentionally misinterpreted by apostates when all it meant was that those expelled from the church could no longer take advantage of the internal ecclesiastical support and justice procedures churches of Scientology provide to resolve disputes and upsets among parishioners. They would have to make their own way, unaided, with the justice procedures of the society as their only recourse. This concept is as old as religion itself. Many faiths reserve the right to expel or excommunicate members who refuse to abide by the moral and ecclesiastical codes of the group. The term fair game does not appear in the scripture of Scientology and has not existed since 1968. In fact, its only use since then is not by the church at all, but by a handful of anti-Scientology apostates and their attorneys who have exploited it in efforts to generate anti-Scientology prejudice in the media or courtroom. Now, here's the thing. I want to revisit this particular sentence here where it says, all it meant was that those expelled from the church could no longer take advantage of the internal ecclesiastical support and justice procedures churches of Scientology provide to resolve disputes and upsets among parishioners. They would have to make their own way, unaided, with the justice procedures of the society as their only recourse. Wow. What would the courts think of this? Now, let me try to sort of steelman Scientology's argument if they were confronted with this, version of publication that appeared on their website. Scientology realists tend to just make things up as they go along, particularly when they're trying to represent themselves to the courts in various ways. I mean, just like they made it up as they went along by saying the Committee of Evidence procedure is the procedure for Scientology's internal arbitration. They just made that up out of whole cloth. Someone just like, oh, say it's a COMEV, say it's a COMEV. We can't say nothing. We can't say there's no procedure, so just say it's a COMEV. Technically speaking, an internal arbitration should be different than your normal justice procedures. After all, an arbitration, in Scientology, when they use the term justice procedures, that's justice in terms of you're being penalized. Scientology's entire ethics and justice system is in the sense of penalizing bad behavior. An internal arbitration is just settling a dispute. In a sense, it's not even necessarily, I don't necessarily put it in the same category as penalizing behavior. And this becomes problematic because a committee of evidence is a form of penalty. There's some policies where L. Ron Hubbard calls it a fact-finding body, but it's a fact-finding body intended to penalize. You don't call a committee of evidence unless you're trying to penalize somebody. Okay, so here, if confronted with this, Scientology would say, well, this would mean that former Scientologists aren't allowed to require us to let them participate in Scientology justice procedures. But it doesn't mean that we aren't allowed to force them to do it. See, this is a one-way agreement. This is a one-way contract. They can't come to us demanding that we do something, but we should still be able to go to them and demand that they do something. And I genuinely would wonder what a court of law would say or think about this. How would a judge interpret this? And immediately as I say that, I'm reminded that one of the problems with dragging Scientology into the courts is Scientology really capitalizes on the fact that the courts are actually prohibited by law from trying to interpret Scientology policy to determine what is fair and accurate. They're not allowed to interpret it in any way, shape, or form, which is really weird when you have Scientology asking the courts to enforce, to affirm the enforceability of their contracts without allowing the courts to interpret the contracts to determine if they are in fact fair. It's a really crazy thing. And it's amazing the courts haven't put their foot down on this and told Scientology, you can't ask us to enforce the validity of your contracts without being able to interpret whether your contracts are in conformity with contract law. And yet that is exactly what Scientology does. This particular language in this particular article that we're looking at here, I found particularly interesting because it's on Scientology's public website, their publicly available, public-facing website. What we're reading here is Scientology's representation of what their own scripture means. We are not reading this text that I'm showing to you right now and reading to you. This is not a direct quote from an L. Ron Hubbard policy. So that means, do you see what I'm saying? If a judge were to look at this website, they're not being asked to interpret scripture. And I know we all sort of, cringe when we hear the word scripture being used with respect to Scientology. Not even Scientologists actually use that word. They only use that word when they're dealing with the courts, right? So a judge, if looking at this and being presented with this, they wouldn't even be being asked to interpret scripture. They would just be being asked to read and understand the representation Scientology is making about its own scripture. And so this might be a bit of a loophole where the courts can determine the fairness or enforceability of something because Scientology itself is making these representations. And again, I just can't help it. I want to quote it again. With respect to the fair game policy, Scientology is saying all it meant was that those expelled from the church could no longer take advantage of the internal ecclesiastical support and justice procedures churches of Scientology provide to resolve disputes and upsets among parishioners, those procedures being a committee of evidence. Okay, those procedures include a committee of evidence. They would have to make their own way unaided with the justice procedures of the society as their only recourse. I mean, there you go. So a judge could ask Scientology's attorneys like, hold on, we don't understand. So your policy is that once you've expelled a member, they are under no circumstances allowed to participate in your internal justice procedures. They have to and they must only use the procedures available through the non-Scientology justice systems. Yes, Your Honor, that is correct. Then how do you expect me to enforce a contract where you are forcing them to participate in the very same procedures that your policy says they're not allowed to participate in after you have expelled them? Oh boy, who knows if anybody will really be able to do anything with this, but I thought it was worth highlighting, especially since this is exactly what is currently at issue in the civil lawsuit against David Miscavige and a handful of Scientology entities. This is the Baxter and Paris versus Miscavige and Scientology et al. Case. It's a huge, important lawsuit currently happening against David Miscavige and Scientology. And the next major decision in that case, other than whether David Miscavige is considered served or not, the next major decision is, in fact, the decision about whether this case is going to be allowed to proceed in the courts or whether the plaintiffs are going to be forced into Scientology's internal arbitration. There's a chance that before that ruling is made, a mini trial might be held specifically on this issue, but that is where we're at. That is currently what is being argued. One side's arguing we should be able to go forward because these arbitration agreements were signed under duress. Scientology's arguing this should go to internal arbitration because they have signed the agreements about internal arbitration. I can tell you that at no point in the case so far has this particular publication from Scientology's own website been introduced into any of the motions or the arguments. And maybe it ought to be. How about that? Okay, everybody, that's all I have on this for now. Thank you for watching and listening. Thanks to everybody who watches until the very end, and I'll talk to you soon.
Okay, if you want to see my rock and roll songs, click right on this guitar. And if you want to see a different one of my videos, then you could click right inside here. If you have subscribed or not, subscribe